But we begin with the Supreme Court. In the entire 220-year-long history of the Supreme Court of the United States, exactly 111 people have served in the capacity of Supreme Court justice. 108 of those 111 have been men. 97.3%. If President Obama's nomination to the court of Elena Kagan today is confirmed by the Senate, that percentage will drop from 97.3% to 96.4%. USA! USA! Here was the president today with his nominee announcing the second Supreme Court nomination of his not yet 2-year-old presidency.
While we can't presume to replace Justice Stevens' wisdom or experience, I have selected a nominee who I believe embodies that same excellence, independence, integrity, and passion for the law, and who can ultimately provide that same kind of leadership on the court. Our Solicitor General and my friend, Elena Kagan.
Thank you, Mr. President. I am honored and I am humbled by this nomination and by the confidence you have shown in me. The court is an extraordinary institution in the work it does and in the work it can do for the American people by advancing the tenets of our Constitution, by upholding the rule of law, and by enabling all Americans, regardless of their background or their beliefs, to get a fair hearing and an equal chance at justice.
If she is confirmed by the Senate, Elena Kagan would join Ruth Bader Ginsburg and Sonia Sotomayor as the third woman on the United States Supreme Court. If she's confirmed, that means that 3 of the 4 women to have ever served on the Supreme Court will all be serving at the same time. If she's confirmed. Modern Supreme Court nomination confirmation battles are about as close to political blood sport as Washington has. As of today, as expected, let the games begin.
It strikes me that if a nominee does not have judicial experience, they should have substantial litigation experience. Ms. Kagan has neither.
Senate Republicans pouncing today on the fact that Elena Kagan has never served as a judge. The last time someone who wasn't a judge was nominated to be a Supreme Court justice was in 2005 when President Bush nominated White House counsel Harriet Miers to fill the seat of Justice Sandra Day O'Connor. That nomination lasted all of 25 days, whereupon Mr. Bush was forced to withdraw his pick for lack of political support. The relevant comparison between Harriet Miers and Elena Kagan is not actually about judicial qualifications. There really are no serious questions about whether Elena Kagan is qualified for the Supreme Court. Harriet Miers had essentially been George Bush's lawyer, and she'd been White House counsel for a hot minute, and that's it. Elena Kagan, on the other hand, is the current Solicitor General of the United States. That's the person who argues the government's cases in front of the Supreme Court. She is the former dean of Harvard Law School. She is a former clerk to the Supreme Court. She has a nationwide, coast-to-coast, sterling legal reputation. She has been a long-time mainstay of Supreme Court speculation. The invocation of Harriet Miers' name right now, again, let me repeat, is not because of the qualifications of these 2 nominees. It's because of this. It's because the thing that killed Harriet Miers' nomination was resistance from the base of the president's own party. Criticism that the president at the time, George W. Bush, had not chosen someone conservative enough, someone with enough of an overt conservative record to settle conservatives' doubts that she would be a solidly right-wing justice.
Advisors say Senate Republicans warned the White House they could not guarantee enough votes for Miers, even from the president's own party.
I hope we can all kind of step back. The president can regroup.
I think the president, will go back to his original criteria, which is to appoint a conservative to the court.
The idea that we now have to roll the dice and wait a number of years to find out if this one works out when it isn't necessary is, I guess, the big bugaboo with me.
It is baffling that the president would have passed over that group of people to pick someone who is such an uncertain quantity.
Such an uncertain quantity. And so, the Harriet Miers nomination was withdrawn. not because of liberals, but because of conservatives. And conservatives were then delighted that the very on-the-record doctrinaire conservative Samuel Alito was nominated for that seat instead. There is no mirror between right and left in this country. There is no liberal equivalent to the conservative movement's level of organization and funding and influence on party politics. But in considering a replacement for the justice who was the court's liberal anchor, with a Democratic president, with a 59-seat Democratic majority in the United States Senate, will liberals, with whatever organization they can muster, be satisfied with a nominee whose credentials as a liberal aren't so much evident in her record as they are expected to be a matter of faith? In a moment, we will hear from Lawrence Lessig, a longtime friend of Elena Kagan, a hugely respected legal scholar in his own right, and a strong supporter of Ms. Kagan's nomination. But first, we will hear from Salon.com columnist and constitutional lawyer Glenn Greenwald, who has been a strong critic of Elena Kagan's nomination. A month before this nomination was announced, Mr. Greenwald wrote a piece on Salon.com called "The Case Against Elena Kagan," which has cast a glow over much of the discussion of this nomination in its early stages. Glenn, thank you very much for coming on the show tonight. It's good to see you.
Good to see you, Rachel.
Is your main concern with Elena Kagan's nomination that there is not enough in her record to satisfy you that she would be a liberal voice on the court, or are there overt things that are in her record that you think are illiberal?
It's both. It's certainly more the former than the latter. And I wouldn't even put it as so much as there's not enough in her record for us to know that she'd be a liberal justice. What the concern is that she's actually a complete blank slate. She's somebody who has managed over the course of the last 20 years to avoid taking a position or expressing an opinion on virtually every single substantial political and legal question. And so for any rational citizen to want to assess the appropriateness of putting her on the court to replace Justice Stevens, there's really absolutely nothing that a person can look to know what kind of judge she can be. There are troubling things in her record, things she said that ought to be questioned about her belief in executive power, her praise for Bush Justice Department lawyers who sanctioned the illegal warrantless eavesdropping program, the utter lack of diversity of her hiring record at Harvard Law School. And these things need to be explored, but the real concern is she has purposely avoided expressing any opinion whatsoever over the last 20 years in a way that makes it impossible for any progressive in good faith to say that they support her nomination.
I want to ask you about some of those overt things in the record that you just mentioned. But first, Glenn, when you wrote your critique of Kagan for Salon a month ago, one piece of her record hadn't yet come to light. That was a letter that she wrote in 2005 with 3 other law school deans. It was opposing a Lindsey Graham proposal about Guantanamo and the courts. And that letter did strongly criticize the Bush administration's expansion of executive power. That's just come out in the last few days. Does that letter, the existence of that letter, leaven your concerns about her at all?
I think that's a positive sign. I mean, there are little snippets that you can sort of glean from her past that are both concerning and encouraging. The fact that she condemned John Yoo memos authorizing torture, albeit 8 years into the Bush administration, the letter that you mentioned condemning the abolition of habeas corpus as a political matter. These are things that are encouraging. There are other things that are discouraging, but none of that really gives us a clue as to how she approaches the Constitution, what her theory of the law is, or of judging, which is really what you want to know before you put somebody on the Supreme Court, especially somebody who, replacing Justice Stevens, could easily move the court to the right if they're not the kind of judge Justice Stevens is. So yes, those are good pieces of evidence, but they tell us actually very little about the kind of judge she would be.
Glenn, one of the things that you have written about, and I think that other people from the left have criticized about Elena Kagan's record, is a discussion that she had during her Solicitor General confirmation hearing with Lindsey Graham. And they were talking about indefinite detention, as you mentioned, the government's right to pick up anybody anywhere in the world, hold them indefinitely without trial. She essentially agreed with Senator Graham when he was expressing his own views about that. Is it possible that in that discussion she was essentially saying what her view was of current law, not necessarily expressing her opinion that she thought it was that law was constitutional or that she thought it was good policy?
No, that's what Kagan defenders have said about that exchange. And it's interesting because the New York Times described that confirmation hearing as when she was confirmed as Solicitor General. They said Republican senators lavished her with every bit as much praise as Democratic senators did. And the reason is because of the types of colloquies that you just referenced. When she was talking to Senator Graham, part of what she was doing was stating the current state of the law. But she went much beyond that. She actually said that the entire world is a battlefield in the war on terror, not just the places where there's armed conflict or where Congress has authorized the use of force. And that it's not just people engaged in hostilities against the United States, but even people much more distantly connected to terrorists, people who finance terrorism or who give material support, who we can hold as enemy combatants as well. That's nothing that the Supreme Court has said. That is not the state of the law. That is something that she said when answering Lindsey Graham that she believed to be true. And that really is a core precept of the Bush-Cheney approach to terrorism that served as an anchor for so much of the radicalism of the last decade. Again, that is not a perfect insight into what she thinks, but it's something that is a little snippet that certainly ought to be of concern to people who oppose the Bush approach to terrorism.